Hello friends, I am Dr. Lakhwinder Singh, Assistant Professor in the Department of Laws, Punjab University, Chandigarh. I am here giving the presentation on the concept of judicial review. The learners' outcome here in this module would be able to understand the concept of judicial review. They would be able to compare the position of judicial review in India with that of the United States and the United Kingdom. Learners would further enhance the knowledge on the judicial review of the state's legislative and the administrative actions. Now, in order to understand the concept of judicial review, we must know the meaning, that what does it mean for. The term judicial review, it means the power of a court to review and potentially strike down an act of legislature as unconstitutional and invalid. Judicial review, it is not a limited term, it means not merely a power of the courts to set aside legislative actions only, but also covers the power of the judicial review of executive or the administrative actions. Judicial review, it is different from right of appeal also. The courts do not act as an appellate authority while doing judicial review. In case of judicial review, the courts inquire how the decision was reached. The superior court scrutinizes the whole the decision making process and checks whether the decision was made lawfully or not. If the superior court finds the decision unlawful, it cannot make a fresh decision but sends the matter back to the decision making authority. Now, the doctrine of judicial review has been originated in the United States, and moreover practices of the doctrine in the United States also influenced many countries in the whole world. In the year of 1803, in the case of Marbury versus Madison, Chief Justice Marshall, he emphasized on the judicial duty to pursue the Constitution in case where a statute is in conflict with the federal Constitution. Marshall further explained that the phraseology of the United States Constitution confirms and strengthens the principle that a law repugnant to the Constitution is void. All courts and other departments are bound to act under the Constitution. Judicial review in the United States has become a very significant weapon to scrutinize all kinds of state actions, legislative, executive and the administrative. Because of such power, the United States Supreme Court has made significant pronouncements and invalidated the state actions on the ground of due process clause. While overruling its earlier judgment of Plessy versus Ferguson, the United States Supreme Court in the case of Brown versus Board of Education invalidated segregated laws dividing whites and blacks and held that separate education facilities are discriminatory in nature. So, basically they invalidated the principle that is separate but equal treatment, and the United States Supreme Court, this court's creativity, it is also being reflected when it recognizes free legal aid in the case of Giddon versus Wainwright and other fundamental rights to the accused person in the case of Miranda versus Arizona. Similarly, in the United Kingdom, the scope of judicial review is narrower because Parliament is supreme over there. Parliamentary supremacy and the rule of law empower the courts to compel the government to act within their limits by legislation. The courts, they cannot substitute their views on the merits of government action for those of the government. However, in United Kingdom, the courts, they examine the actions of public bodies and protect the will of the Parliament. The courts check whether the bodies are functioning within the powers they have been given. If bodies act outside those powers, the courts consider it void as it is against the intention of the Parliament. In the very famous case, in the Council of Civil Service Union versus Minister for the Civil Service, Lord Diplock classified the grounds of judicial review under the three heads, that is illegality, irrationality and procedural impropriety. he also recognized that further concepts such as proportionality might evolve. Now, so far as India is concerned, in India it is the judiciary who is the guardian of the Indian constitution. The courts have power to review all legislative enactments, executive and administrative actions. The Indian constitution, they explicitly provides for judicial review through articles 13, 32, 131 to 143, article 226 and 246. In contrast to the judicial review of legislative action, the courts in India, they use the power of judicial review more against the excesses of administrative action. Dr. B.R. Ambedkar said that the provisions for judicial review, in particular the writ jurisdiction, would provide quick relief to the individuals against the abridgment of fundamental rights. In the famous case, in the case of A.K. Gopalan versus State of Madras, the Supreme Court said that the constitution is supreme and every statute has to be in conformity with the constitutional requirements. Binding duty of the courts, it is a binding duty of the courts to decide whether any law or statute is constitutional or not. So, Supreme Court imposed a duty on the courts that they are the real guardians of the constitutions, they will have to protect the spirit of the constitution. So, they should review every action of the state, of the government, that whether they are performing their functions in a limited manner or whether they are performing their function in an absolute manner. In the case of State of Madras versus Roe, the Supreme Court said that it is the most important duty of the court to determine the constitutionality of an impugned state. Another case is of S.S. Bola versus B.D. Sardana, in which the Supreme Court observed certain things, that the founding fathers wisely added the provision of judicial review for maintaining federalism, protecting fundamental rights and strengthening the concept of liberty and equality in India. Another case, Subhash Sharma versus Union of India, the Supreme Court said that the judicial review is a basic feature of the Indian constitution. The court held that the Chief Justice of India, they should play an active and major role in the process of appointment of judges of High Court and the Supreme Court. In the very famous judgment in the year of 1997, the case was L. Chandra Kumar versus Union of India, in which the High Court's jurisdictional power under Article 226 and 227 and Supreme Court's power under Article 32 were declared the basic structure of the Indian constitution. The Supreme Court declared that clause 2d of Article 323A and the clause 3d of Article 323B unconstitutional to the extent they excluded the jurisdiction of the High Court and the Supreme Court under Article 226, 227 and 32 of the Indian Constitution. Another case, Sampath versus Kumar versus Union of India, the Supreme Court said that the judicial review, they cannot be abrogated by the Parliament, since it is an essential feature of the Indian Constitution. Without the provision of judicial review, the enforcement of fundamental rights would be meaningless. Another case, that is of Minerva Mills versus Union of India, the Supreme Court said that fundamental rights would become a piece of decoration without power of judicial review. So, the importance was given to the concept of judicial review, that in order to maintain rule of law in our country, judicial review is very important. The power of judicial review should be given to the courts in a more wider way. Another case was the state of West Bengal versus Committee for Protection of Democratic Rights. In this case, the power of the judicial review of the High Courts and the Supreme Court under Article 226 and 32 respectively were declared again the basic structure of the Indian Constitution, and this the court said that it cannot be abolished by an act of Parliament. The Supreme Court said that the judicial review gives the practical shape to the objectives of the Indian Constitution. The court said that the Supreme Court and the High Courts can invalidate a legislative action which violates federal structure of our nation. Very important judgment was of Goloknath versus State of Punjab, in which the Supreme Court said that the Article 32, 141 and 142 of the Indian Constitution, it enabled the Supreme Court to formulate legal principles to reach the ends of justice. In the case of Gridco Limited versus Sadanand, the Supreme Court said that the power of judicial review under Article 226 can be exercised even in those cases where the government is involved in contractual transactions. The court said that a writ court is entitled to review the administrative action on the ground of illegality, unreasonableness, unfairness or irrationality. However, the writ court cannot act as an appellate authority while exercising its power of judicial review. Similarly, the writ court cannot sit as an administrator to decide whether a more reasonable decision or cause of action and could have been taken in the circumstances. So, at the maximum what the court could do while exercising its power of judicial review, that they can remit the orders back to the deciding authorities or the administrative authorities. Now, so far as Indian Constitution is concerned, again Article 13, it lays down the procedure for judicial review in India. It enables the courts to examine the constitutional validity of laws passed by the parliament and the state legislatures. In India, the judicial review of legislative action is being done by using some basic principles of constitutional law, that is, doctrines of pith and substance, colorable legislation, severability, doctrine of liberal interpretation, limitations of state decisions, unconstitutionality, eclipse and the waiver. These are the certain doctrines which the Supreme Court has developed over the period of time to examine or to scrutinize the legislative actions. The doctrine of basic structure is also one of the most reliable ground for judicial review. Article 13 of the Indian Constitution, it deals with the statute law and not with the law declared by the courts or with the directions or orders made by the Supreme Court under Article 142. Article 13, it provides the fundamental rights will prevail over all laws in force before the commencement of the Constitution. It also prohibits the making of any law, rule or any regulation, etc., that violates or diminishes the fundamental rights. However, this provision does not impose a restriction on the process of constitutional amendments. Parliament may amend any constitutional provision while exercising of its constituent power in accordance with the procedure mentioned under Article 368 of the Indian Constitution. In the year of 1967, in the case of Goloknath versus State of Punjab, the Supreme Court said that the Parliament cannot amend the fundamental rights. The court held that the procedure laid down for the constitutional amendment in Article 368 was law within the meaning of Article 13. But later on, in the year of 1973, in the again landmark judgment of the Honorable Supreme Court of India, that is the Keswanand Bharti versus State of Kerala, in which the Supreme Court said that Parliament is allowed to amend the Constitution, but it is not authorized to amend the basic structure of the Indian Constitution. In this case, the Supreme Court ruled that 24th, 25th and the 29th amendments were unconstitutional to the extent that they violate the basic structure of the Indian Constitution. In doing so, the court overruled the majority opinion of Goloknath's case. Again, in order to prevent any kind of chaos, the Supreme Court applied the doctrine of prospective overruling also in this case. Now, the courts in many pronouncements have declared that the democracy, secularism, rule of law, federalism, judicial review, separation of powers, etc. They are the basic features of the Indian Constitution. Even in the case of Indira Gandhi versus Indira Gandhi versus Raj Narayan, the year of 1975 Supreme Court, the Supreme Court said that the ordinary laws are not subject to the test of the basic structure of the Indian Constitution. The doctrine of basic structure is applied only to determine the validity of constitutional amendments. In the year of 1980, the famous case Minerva Mills versus Union of India, the Honorable Supreme Court was requested to assess the constitutionality of the 42nd Amendment, which provided that no amendment would be challenged in any court of law or any ground. The court unanimously held that the provision was void since it violates the basic structure of the Indian Constitution. Another case, very important case, State of Rajasthan versus Union of India, 1994, in which the proclamation of emergency under Article 356 clause 1, the Supreme Court said it does not have any kind of immunity from judicial review. The Supreme Court or the High Court, they can strike down the proclamation if the court finds that it was decided on mala fide or irrelevant or extraneous grounds. So the President action is not absolute, it is still subject to judicial review on certain grounds. In the year of 2006, another judgment came, that is M. Nagaraj versus Union of India, in which the 4 constitutional amendments, that is 77th Amendment, 81st Amendment, 82nd Amendment and 85th Amendment were challenged. Basically the amendments, they enlarged the scope of reservation and it was challenged. It was contended that such amendments were made by the government in order to override the effect of previous Supreme Court's decisions. However, this court said that the concept of catch-up rule and consequential seniority are not constitutional principles like secularism, federalism, etc. Therefore, the Supreme Court said that the decision, deletion or addition of such concepts do not change the equality principle embedded under Article 14, 15 and 16 of the Indian Constitution. It was concluded that such amendments do not damage the basic structure of the Indian Constitution. In the year of 2007, very famous judgment that came into picture, that was I.R. Kolo versus State of Tamil Nadu. Now in this, the Supreme Court said that all constitutional amendments made on or after 24th April 1973, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of the basic features of the Constitution enshrined under Article 14, 19 and 21. In order to clarify the situation, the court further declared that even though an act is put in the 9th schedule by constitutional amendment, its provisions would still be subject to the judicial review, and it would be tested on the ground that whether they have destroyed the basic structure of the Indian Constitution or not, or whether they have abrogated the basic structure of the Constitution or not. So judicial review has been developed in case of legislative action by applying these doctrines. Now there is also one important thing regarding judicial review, that is judicial review of administrative action is again a wider version of the concept of judicial review. In India, judicial review of administrative action has been developed in order to regulate every action of the administrative authorities. In the process of judicial review of administrative decision, the writ court does not sit as an appellate court. Again, it is not for the writ court to replace its own decision against the decision of the administrative authorities. The court scrutinizes the whole administrative action and sees how the whole action was reached. If the court finds an administrative action as arbitrary or irrational, the court sets aside the whole action and sends back the matter to the administrative authority for re-examination. There is a case in the year of 2004, Delhi Development Authority versus Messrs UEE Electricals Engineering Private Limited, in which the Supreme Court said that the illegality, irrationality and the procedural impropriety are grounds for judicial review of administrative action. Courts do not interfere in an administrative decision unless the decision is an outcome of an unfair procedure. Mere suspicion of unfairness would not be sufficient. The claimant has to prove the unfairness in the administrative action in any of its form, including abuse or a misuse by the authority of its power. Lord Green in Associated Provincial Pictures Houses Limited versus Wednesbury Corporation, the court, the Lord Green said that the administrative action is unreasonable if the action is based on wholly irrelevant material or on wholly irrelevant considerations, or if the action is irrational. The doctrine of proportionality is another important basis for exercising judicial review. This doctrine is well recognized, the concept of judicial review. If the administrative authority awards the disproportionate punishment, definitely it becomes necessary for the judicial court to intervene. Award of punishment which is grossly disproportionate to the allegations cannot claim immunity and remains open for interference under limited scope of judicial review. In India, we do not have any uniform code which directs the administrative authorities to adopt minimum procedure for taking any of its action, but Indian courts have recognized the principles of natural justice, that is rule of fair hearing and rule against bias, as a precondition for administrative action. So basically these are the grounds on which the judicial review of the administration action can be taken. Indian judiciary it has also widened the scope of these principles by making the authorities more accountable and answerable in their actions. The courts emphasize on its applications in all cases, irrespective of the fact that whether it is compulsory under some statute or not. Moreover, the principles of natural justice are very wide in scope, and it includes various modes of fairness. Similarly, the observance of principles of natural justice is necessary not only in cases of quasi-judicial functions, but also in other kinds of administrative action. Currently, administrative authorities, they are supposed to conduct inquiries in good faith and without any kind of biasness. The requirement of acting judicially in essence is nothing but a requirement to act justly and fairly and not arbitrarily or capriciously. So basically it does not matter what kind of function the authority is performing, whether it is purely administrative function, whether it is merely investigatory function, whether it is quasi legislative function, whether it is quasi judicial function, it does not matter. There should be a fair play in action. The whole action should have come out with some reasonable procedures, that reasonable principles were followed while taking these decisions, these administrative decisions. If there is anything flaw in that process, then it will be subjected to the judicial review. So judicial review has been of administrative action has been developed. Similarly, the doctrine of legitimate expectation is also one of the ground of judicial review, and it was originated in the case of Simdit versus Secretary of State 1969. In this case, it was held that an alien who had been granted permission to enter the United Kingdom for a limited period had a legitimate expectation for being allowed to stay for the permitted period, and if you are cancelling his passport or if you are cancelling the the stay, then he has a right to be legitimately concerned, that the legitimate opportunity of being heard should have been given to him before impounding his passport, or before cancelling his passport, or before cancelling his stay. So, that is a doctrine of legitimate expectation. Similarly, this doctrine has been developed, it has been adopted by the Indian courts also, although it is not a legal right, but still it is of it is very valuable so far as judicial review of administrative action is concerned. Now, while dealing the nature and scope of legitimate expectation, the Honorable Supreme Court of India, in the case of Union of India versus Hindustan Development Corporation 1993, they explained that the legitimacy of an expectation can be inferred only if it is founded on the sanction of law or custom, or an established procedure followed in regular and natural sequence. It is mandatory that the legitimate expectation should be justifiably legitimate. Expectation should be justifiably legitimate and protectable, and every such legitimate expectation does not by itself fructify into a right, and therefore it does not amount to a right in the conventional sense. We have discussed in this module the concept of judicial review, that how this concept of judicial review has been developed, and how, where it was originated, and what does it basically mean. And in the United States we discussed the Marbury versus Madison's case in which it was originated, and we discussed basic very landmark judgments over there, that what happened actually when the Supreme Court of United States, they invalidated certain laws which were carrying the old principle, that is separate but equal treatment. Similarly, they recognize certain rights to the accused person while invalidating the unconstitutional enactments, and they also provided the free legal aid to their individuals. And we also discussed in this module the United Kingdom's position, that how the judicial review is limited in United Kingdom, and the scope is very narrow in the United Kingdom, and how the parliamentary supremacy is there, and but the courts, they have devised new things in which they protect the intention of the parliament, they protect the will of the parliament, and they challenged the administrative actions, administrative courts action or quasi judicial actions, but in that process they cannot substitute their own decisions. Even in India we discussed this thing, that while reviewing the any authority's action, the courts, they cannot replace their own decision with the deciding authority, the administrative authority's decision, but they can remit the matter back to the authorities, so that they can take a fresh look over that thing. And we also discussed that how in India this concept of judicial review has been developed. Basically it is certain constitutional provisions which gives the power of judicial review to the Indian courts, and like Article 13 is there, very important constitutional provision which provides this power of judicial review to the Supreme Court of India and the High Court, and in which prohibits all kind of rules and regulations and all kinds of actions which are unconstitutional, and they makes a restriction, they puts a restriction on the authorities, that they cannot overreach their powers. And we discussed certain case laws in which the Honorable Supreme Court of India has said that the judicial review is the basic feature of the Indian Constitution, and which cannot be abrogated and which cannot be amended, and because this, it carries the basic spirit of rule of law, and rule of law is there if there is a power of judicial review with the courts. And this concept of judicial review has not only been developed in the judicial review of legislative actions, but it has also been developed in the in cases of judicial review of administrative actions, where the administrative authorities, if they are performing the public functions and if they are performing any function like quasi judicial function or quasi legislative function and any administrative or the investigating function or the pure ministerial functions, even those actions they should behave properly, they should act fairly, and if they violate any of the principles of natural justice, or if they violate somebody's doctrine of if they violate somebody's legitimate expectations of, or if they have acted or if they have acted disproportionality in the whole process, then it is subject to judicial review. So it has been developed in India in this manner also, and it is it is very important for the courts to have such power, so that the authorities they cannot overreach its powers. Similarly, the very famous, we discussed a very famous judgment, that is of I.R. Kolo in the year of 2007, in which the Supreme Court has put more restrictions on the legislative actions, on the legislature also, okay, that parliament they cannot their action cannot be absolute, and it is every action, if it has come out with some unreasonable things in which they have done certain unconstitutional things, then they are subject to the doctrine of basic structure, and it's a very important weapon, and it's a very strong weapon in the hands of the Indian judiciary, in which they protect our fundamental rights. With this I conclude it. Thanks.